Welcome to Remax of Boulder video podcast. Today we have Jon Goodman from Frascona Joiner Goodman Greenstein, the prestigious law firm here in Boulder, Colorado. Jon, thanks for joining us today.
Thank you, Duane. Nice work with the name.
Yeah, thanks. Today our topic is the seller's obligation to disclose information about a property in a real estate transaction. So I know Jon doesn't like me to talk about history too much, but I'm so old that when I started selling real estate, there was no property disclosure form. So things have evolved quite a bit. So things have changed. What are the thoughts about disclosure when I am sitting at a kitchen table working with the seller on the listing? The general rule of disclosure, when the seller asks me, should I disclose the problem about the blank? My answer is always yes, you disclose everything you can. But Jon, let's kick this off with, is the seller property disclosure form actually required in the state of Colorado?
Duane, there is no statute, there is no case in Colorado that requires a seller to actually use the Division of Real Estate's form.
Okay, and so I noticed like a year ago there was a checkbox in our contracts that said the seller agrees or didn't agree to provide the seller property disclosure form. In our new contracts for 2016, that checkbox went away. Can you say a little bit about why that happened or why a seller ought to provide a seller property disclosure form, whether it was required or not?
Duane, that's a compound question.
Sorry about
I'm
that.
not sure if I answered a compound question. So let me break that down into two questions. I'll see if we can answer that. So one question is even though there's not a state law that requires sellers to actually use the Real Estate Commission's approved form, it is a good idea for sellers to use that form for two reasons. One of those reasons is that sellers do have an obligation under Colorado law to make certain disclosures. They have an obligation to disclose what the law calls latent material defects. And if a seller is going to make disclosures, they might as well use the Real Estate Commission approved disclosure form for two reasons. One of them is it's expected in the marketplace. That is,
right.
Buyers and the brokers who are working with buyers are used to seeing that form. Another reason is that there's a very handy protocol, and part of making disclosure is proving that the buyer was aware of the disclosure, and there's a very handy protocol at the bottom of that form. There's a place for a buyer to sign acknowledging receipt of the form, and buyers and their brokers are used to signing it. And now as I talk, I think there's another reason to use that form, which is that a lot of times, especially if we've owned property for a long time, we forget about certain things. We get used to certain things, and the form is nauseatingly long and has a lot of rows that might prompt a seller to disclose something they might not otherwise remember.
Okay, and I know one thing about the form, it has grown. It's like 7 pages now. One of the general thoughts is the seller should fill it all out, the broker should never touch it, and there's obviously various opinions upon that. But I think that when, again, you're at the kitchen table, if the consumer or the seller tries to do it on their own, it is kind of complex, so it's very good for the broker to help them as far as at least get the answers in the right columns, because otherwise they can kind of make a mess of it. So I think they do need a little bit of guidance. But Jon, what about when the seller has never lived in the property? There's a few cases where that will be the case. What happens then with the seller property disclosure?
Okay, the seller has never lived in the property. I'm going to come back to that. But
okay.
Remember, there's a question hanging here that I haven't answered, and that was your question. Jon, there used to be a checkbox if the seller will or will not provide the form. Why has that been removed?
Thank you.
And I think it's been removed to do everything that we can to avoid the impression that a seller might get that they don't have to use it. The state regulator is trying to encourage the use of that form, and having a checkbox, no, it won't be provided, is something that may cause a light bulb to go off in the seller's mind. Oh, I don't need to use this form.
Especially like in what we were leading to the next part of the topic is if they haven't lived there, they might be very tempted to just say, I haven't lived there, I'm not providing it.
Right. So one of the trickiest areas, one of the areas that gets sellers in trouble is when a seller concludes they don't know anything about the property because they haven't lived in the property. And generally that's just not the case. The seller may not have lived in the property. I had a rental. My wife and I had a rental for 17 years. We never lived in the property, and I probably spent about 45 minutes of my life in that property over the 17-year period. Did that mean I didn't know about problems with the property? No. Periodically I'd hear from my tenant. My tenant would complain about this and that. we'd make arrangements to have this or that fixed, we'd pay bills. Just because the seller hasn't lived in the property does not mean that the seller is ignorant of problems. And usually it's quite the opposite. So not living in the property is not an excuse for avoiding filling out the form.
Okay, and that makes sense in the rental property world. John, what about like an estate? Let's say there's a personal representative handling the estate. They've maybe never even been to the property, and now they're charged with selling it. What's a seller like that do about the seller property disclosure form?
So in those situations, there are occasionally a personal representative of an estate that doesn't know anything about it. But again, in my experience, it's more common that they know something about the property. They list it with a listing broker. Their listing broker says, in order to make this property more attractive to the market, we need to fix this, that, and the other thing. Maybe before they listed it, maybe while they were in the process of probating the estate, they were paying bills for the leaky roof, or they were paying bills to replace the windows. So in most situations, even the personal representative from the estate knows something about the property. Now let me anticipate your question.
Okay.
But John, surely there are some personal representatives who know nothing about the condition of the property. And that is occasionally true. And if that's absolutely true, I think they should still use the form, and where they can honestly check the I don't know box.
Right.
There are columns to check I don't know, and they can check I don't know. They need to pay attention, because if they check I don't know in response to a question, are you aware of such and such a problem? If they're not aware of such and such a problem, they check no, not I don't know.
Right.
Just because the seller isn't aware of a roof problem, for example, doesn't mean there isn't a roof problem.
Right.
So unless the sellers check something out themselves, even if the seller has lived in the property, the seller should check I don't know.
Okay, and I thought of one other seller in this marketplace that we see quite a bit, and that's the fix and flip. What kind of special issues are there, and have been any cases in Colorado or that you use relative to fix and flip disclosures?
Sure. Fix and flip situations create interesting disclosure dilemmas. One of the reasons is that they feel like lenders, like banks who have foreclosed on property, and banks try and sell property as is without making any disclosure obligations, without making any disclosures. Fix and flip sellers try and do the same thing because they perceive it reduces their liability. But there's a very recent case in the state of Colorado. It's called In Regatas, where there was some fix and flip entrepreneurs. And yes, they hadn't lived in the property, but did that mean they were ignorant of the problems in the property? No, they were professionals. They knew, in this case, that there were structural issues with the property. They had them diagnosed. They purported to fix them and didn't disclose any of that to the buyers. Post-closing, the buyers had problems, and the fix and flip entrepreneurs got hammered by the court system.
Okay, and so in that case, the lesson learned there that if there were major repairs in a fix and flip, the whole repair process should have been disclosed from the initial findings to what the repairs were and what was done.
Yes.
All right, John, is there anything else that comes to mind as far as seller disclosures?
No, Duane, I think we've covered it, what we need to.
John, thanks again for always being here. Appreciate your input.
You're welcome, Duane.
Remax Boulder Video Podcast, signing off.